Be ready. Start. It is clear from the above that where the plaint does not disclose a cause of action, the relief claimed is undervalued and not corrected within the time allowed by the court, insufficiently stamped and not rectified within the time fixed by the court, barred by any law, failed to enclose the required copies, and the plaintiff failed to comply with the provisions of Rule 9, the court has no other option except to reject the same. A reading of the above provision also makes it clear that power under Order 7 Rule 11 of the Code can be exercised at any stage of the suit, either before registering the plaint or after the issuance of summons to the defendants or at any time before the conclusion of the trial. A perusal of Order 7, Rule 11 CPC makes it clear that the relevant facts which need to be looked into for deciding an application thereunder are the averments in the plaint. The trial court can exercise the power under Order 7, Rule 11 CPC at any stage of the suit before registering the plaint or after issuing summons to the defendant at any time before the conclusion of the trial. For the purposes of deciding an application under clauses A and D of Rule 11 of Order 7 CPC, the averments in the plaint are germane. The pleas taken by the defendant in the written statement would be wholly irrelevant at that stage. Therefore, a direction to file the written statement without deciding the application under Order 7 Rule 11 CPC cannot but be procedural irregularity touching the exercise of jurisdiction by the trial court. It is clear that in order to consider Order 7 Rule 11, the court has to look into the averments in the plaint, and the same can be exercised by the trial court at any stage of the suit. It is also clear that the averments in the written statement are immaterial, and it is the duty of the court to scrutinize the averments pleas in the plaint. In other words, what needs to be looked into in deciding such an application are the averments in the plaint. At that stage, the pleas taken by the defendant in the written statement are wholly irrelevant, and the matter is to be decided only on the plaint averments. It is clear that if the allegations are vexatious and meritless and not disclosing a clear right or materials to sue, it is the duty of the trial judge to exercise his power under Order 7, Rule 11. If clever drafting has created the illusion of a cause of action as observed by Krishna Iyer J. in the above referred decision, it should be nipped in the bud at the first hearing by examining the parties under Order 10 of the Code. While scrutinizing the plaint averments, it is the bounden duty of the trial court to ascertain the materials for cause of action. The cause of action is a bundle of facts which, taken with the law applicable to them, gives the plaintiff the right to relief against the defendant. Every fact which is necessary for the plaintiff to prove to enable him to get a decree should be set out in clear terms. It is worthwhile to find out the meaning of the words cause of action. A cause of action must include some act done by the defendant, since in the absence of such an act, no cause of action can possibly accrue. A cause of action means every fact which, if traversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. In other words, it is a bundle of facts which, taken with the law applicable to them, gives the plaintiff a right to relief against the defendant. It must include some act done by the defendant, since, in the absence of such an act, no cause of action can possibly accrue. It is not limited to the actual infringement of the right sued on but includes all the material facts on which it is founded. It does not comprise evidence necessary to prove such facts, but every fact necessary for the plaintiff to prove to enable him to obtain a decree. Everything which, if not proved, would give the defendant a right to immediate judgment must be part of the cause of action, but it has no relation whatever to the defense which may be set up by the defendant, nor does it depend upon the character of the relief prayed for by the plaintiff. It is mandatory that in order to get relief, the plaintiff has to aver all material facts. In other words, it is necessary for the plaintiff to aver and prove in order to succeed in the suit. Similarly, a power of attorney is not an instrument of transfer in regard to any right, title, or interest in an immovable property. The power of attorney is creation of an agency whereby the grantor authorizes the grantee to do the acts specified therein on behalf of grantor. Thank you.